welcome to this webinar on data transfers to countries outside the European Union under the General Data Protection Regulation. My name is Alan Calder. I'm the Chief Executive and Founder of IT Governance, and I will be taking this webinar this afternoon. There's about 40 or 45 minutes worth of information that I'm going to share with you. You may find that you've got questions that you want to ask as we go through the webinar. Please do use the questionnaire questions function in GoToWebinar, which should be sitting in the panel on your right-hand side. You can type questions into that, and when we get to the Q&A section, what I'll do is I'll go through the questions, I'll read them out and then share with you my answer. I've been involved in data protection now for coming up 20 years, ever since the company which I was then leading was the first company in the world to be certified to the forerunner of what's now ISO 27001. The book I wrote about it is in its 6th edition, has been the Open University textbook on information security for some years, and of course the link between information security or cybersecurity management and data protection has become very clear with the arrival in the corporate strategic pathway of the General Data Protection Regulation, and that's what we're going to be talking about today. IT Governance as a company is able to draw on many years of experience across a broad range of cybersecurity, resilience and data compliance issues to inform the kind of areas that we're talking about in this webinar. We deliver information security, data protection, compliance services across a broad range of channels, from books, tools, software, classroom-based training, e-learning and consultancy, putting together packages of services to meet the needs of our clients to address their compliance and cybersecurity issues. And of course, GDPR is one of the most significant areas facing organizations today. So we're going to have a brief overview of the regulation. Some of you may not yet be fully aware of the key drivers, but we're going to be moving through the rights of data subjects to look at the international transfer of data and the safeguards that apply to them. There are some derogations that apply to prohibitions about data transfers outside the European Union, European Economic Area. We'll have a look at those. We'll look at the role of the supervisory authority in international transfers. And I hope that by the end of this webinar, you'll have a much better handle on the steps that are necessary to ensure that you don't find yourself falling foul of the requirements under GDPR, which are at their most severe in relation to breaches of the core 6 data protection principles, the rights of data subjects and the international transfer articles. So first of all, the who and where. The GDPR applies to natural persons, that's not companies and not dead people. It applies to individuals who are whose data is processed by an organization, an entity, and the entity can be a natural or a legal person, which itself is based in the European Union, or alternatively which is based outside the European Union but providing services into the European Union. And GDPR says that natural persons have rights to have their personal data protected, to have how the personal data is processed protected, and to the unrestricted movement of personal data within the European Union. And so in material scope for GDPR is any data that's processed wholly or partly by automated means, or that's part of a filing system or intended to be. And that really means that unless you're planning to store your data in an unregulated heap of calling cards in the corner of your office, virtually any data that you gather, irrespective whether it's digital or analog, is going to be within the scope of this regulation. And it applies to controllers and processes irrespective of where they're based. If you're inside the European Union, or as I said, outside it, but providing services into the European Union, you're going to be required to ensure that natural persons' rights are protected. And that means natural persons irrespective of their place of residence or their nationality. So it's not just simply if you're outside the European Union, you have to worry about European Union citizens. If you're outside the European Union and providing services into the EU, anybody within the EU that accesses those services is entitled to the protections of GDPR. And it's that, the relationship between the rights of natural persons and the data protection principles, that drives the whole body of the legislation. Where natural persons, where data subjects believe that their rights have been infringed as a result of how we data controllers set about processing their data, they have a right to bring an action, and their right to bring an action is something they can exercise where they live, where you're based, or wherever it is that they think the transgression took place within the member states of the European Union. Not only do they have a right to bring an action, a right to judicial remedy, they've also got a right to compensation, and that compensation can be in relation to both material and non-material damage. Non-material damage includes the sense of frustration, depression and upset that data subjects might feel that they have experienced as a result of the way you process their data, and there's no ceiling on the size of the compensation that data subjects can seek. Where a controller outsources some of the processing to a processor, the processor is going to be liable under GDPR for damages caused by that processing. So the first area of concern for any organization that's processing personal data is the right of data subjects to bring an action where they feel that their rights have been transgressed. The second area of concern is of course going to be around the administrative fines, where supervisory authorities are in a position to levy fines on organizations for breaches of the data protection requirements, up to 10% or 2% of total worldwide annual turnover in terms of the range of minor transgressions, and up to 4% or 20 million euros where major transgressions are concerned. And major transgressions are those which relate specifically to the 6 data protection principles, to the rights of data subjects, and to the trans-border data flow requirements. So the subject of today's webinar, of course, is very much around that trans-border data flows. The regulation comes into force on the 25th of May 2018. It applies across all the member states of the European Union. You can download and get a copy of the final text of the regulation from this link on this slide, and these slides will all be sent out over the course of the next 24 hours or so to attendees on the webinar, so you'll be able to click on the link and access this information yourself. We're already slightly over halfway through the transition period. This is not a regulation which you have to start your compliance journey towards in May next year. This is a regulation with which you need to be in compliance by May next year, which means that everything you're doing, all the data you're processing, needs to meet the requirements of GDPR. And the key definitions are, first of all, what a personal data breach is. A personal data breach is any compromise of security that leads to an accidental or deliberate destruction, loss, alteration, or unauthorized disclosure of personal data. So the 45 NHS trusts that found that data was unavailable for a period of time a couple of weekends ago as a result of the WannaCry breach were organizations that suffered under GDPR. A very clear data breach would be under the obligation to report that data breach. Where the NHS trusts, for instance, were themselves controllers, they were the organization determining what data should be collected, the purposes for which it was collected, and the extent to which what processing would take place and how long it would be kept. Data controllers have to notify supervisory authorities within 72 hours of experiencing the breach. So an NHS trust which experienced the breach on Friday morning would have until would have 72 hours, so that's until Monday, to report that breach to the GDPR. But it's not just saying we've had a breach. When you report the breach, you need to explain what happened, why it happened, what mitigating steps you're taking to deal with it, and if, of course, it has a significant impact on the data subjects, on their rights and freedoms, you need to talk directly to the data subjects as well. If, as a controller, you've outsourced some of the processing to another organization, what's termed as a data processor under the regulation, the data processor, if it's breached, has to first of all be operating under the terms of a contract with you, the data controller, and has to, if there is a breach, as soon as it identifies the breach, has to notify the data controller without undue delay. We don't yet have clarity from the European Data Protection Board in terms of what undue delay means, but we certainly are clear that the obligation by processor to report to controller and controller then to report to supervisory authority in terms of United Kingdom Information Commissioner or Commissioner's Office, and possibly where there's a high risk to the rights and freedoms of data subjects, also to those data subjects, is a very clear set of requirements. And the failure to report a breach itself will trigger fines up to 2%, but the failure to deal properly with data subject rights is going to trigger the higher level of fines. And remember that the requirement is that organizations take appropriate measures to provide any information about data processing to the data subject in a easily accessible form using clear and plain language, that you have to facilitate the exercise of data subject rights, and that you also have to put in place appropriate measures to protect the confidentiality, integrity and availability of data. Any of those breaches can lead to painful fines. So the key rights, the rights of data subjects, start with the right to, if consent is the lawful basis for processing, to consent. If consent is the lawful basis, then they have a right to withdraw consent and to see withdrawal of consent acted on. They have a right of access to know that the data you're processing has been processed in line with their requirements, to have put right any errors that they identify, to erase data that is incorrect, or where the purpose of processing is no longer in force, to be forgotten if you like, to restrict processing while arguing over an objection, and of course to object to processing where there is a basis of processing other than consent. In addition, they've got a right to their data being portable, a right to withdraw consent, as I said, at any time, the right to lodge a complaint with the supervisory authority, and in particular the right to be informed of the existence of automated decision-making and the consequences to them of that decision-making. Any data subject access request will have to reveal that data is being held outside the United Kingdom or outside the European Union, and if that's the first time that a data subject is aware of it, they're asking, and it's a requirement that you tell them if you're processing data outside the EU. If they discover at that point that you haven't told them, they're entitled instantly to exercise any of their rights, the right to object to what you're doing, the right, if they can demonstrate that what you're doing is unlawful, to have the data you're holding erased. So being on top of the rights of data subjects is critical, and the rights of data subjects themselves, while under the Data Protection Act were the sixth data protection principle, they've been removed from the data protection principles and become a separate chapter in GDPR, as has what was the eighth principle, the transfers. That's no longer a principle, it gets a whole chapter of its own in GDPR. So principle, so rights of data subjects and extraterritorial transfers now come out of the six data protection principles, which are by definition therefore reduced to six, and get chapters of their own. And substantially what this webinar is about is the rights of data subjects in regard to transborder data flows and the lawful basis on which you can move data outside the European Union. The logic, if you like, is that when a data subject agrees to you processing their data, it's in the knowledge that you're doing that within the European Union, that there is a particular right of legal framework within which they can be sure that they can exercise their rights as data subjects. If therefore you propose moving the data outside the European Union, there is the risk that you're moving it to a jurisdiction where the rights of data subjects will not have the same level of protection, and therefore GDPR says that it's simply not allowed. We're going to talk a bit about how you can go about actually transferring data, the circumstances under which it becomes legal, and we're going to look at the existing arrangements which exist between the EU and the US around the transfer of data. And as I'm talking about this, do bear in mind that beyond March 2019, when the United Kingdom will ostensibly or apparently have left the European Union, will be outside of the EU, will no longer be able to transfer data to other EU entities on the basis of all being within the European Union, will be outside of it. So if as a provider or controller outside the European Union providing services into the EU, we wish to go on doing so, we'll need to be able to be sure that we also meet the requirements to be able to process data from an EU organization. So the general principle for data transfers is set out in Article 44 of GDPR. It says that any transfer of personal data has to be protected by the certainty that if it's being transferred, the country to which it's going is adequate, it has an adequate legal regime, and that's a decision to be made by the European Commission. Alternatively, there are appropriate legal safeguards put in place by means of contract and assessment between a data controller in the European Union and another controller or processor outside the EU, or alternatively, for an international group, there are binding corporate rules. The key principle is that in transferring data in the arrangements put in place between entities inside the EU and those outside, everything has to be done to ensure that the rights of data subjects are protected, those rights that we talked about, and that includes obviously the right to access, the right to be able to get copies of information, get to know exactly what you're holding about them. So, for instance, somebody is entitled to know what's been said about them in emails, which means they're entitled to information from email archives. If the email archives are held outside the European Union, you nevertheless need to be able to provide that information to the data subjects. So, first of all, transfers on the basis of adequacy. And the adequacy criteria, in other words, a country is determined as being adequate if it is identified as being subject to the rule of law. The rule of law recognizes respect for human rights and for the fundamental freedoms of human beings, and there is appropriate legislation in place both on a general and a sectoral basis which covers public security, defense, national security and criminal law, and which provides for protection of the rights of natural persons in the context of that legislation. And where the European Commission judges another country to meet those requirements, it'll make a decision that it has an adequate legal environment, and it will publish a list of those countries on the EU website in the official Journal of the European Union, published on the EC website. So it's relatively easy to know which countries meet the adequacy requirement, and the answer is, first of all, that any organization that is operating within one of the European Union member states or within a member of the European Economic Area is defined as meeting the requirements of GDPR. So if you consider the intention of the UK government to leave both the European Union and the European Economic Area, from a data protection point of view, means by definition that Britain will no longer fall within the scope of an automatic adequacy finding. It will have to seek an adequacy finding directly, and that means it will fall into, assuming that it's successful in doing that at the same time as all the other issues for Brexit have to be negotiated, it will fall into the group of companies of which there are currently 11 which meet the adequacy requirements but which are not in the European Economic Area. Amongst the larger countries, you'll notice Canada, New Zealand, Uruguay, but otherwise they're all relatively small countries. You'll notice in particular that the United States is not listed amongst those countries that meet the adequacy requirements, nor is India, nor is China, nor are many of the destinations which are seen as appropriate places either to base cloud service centers or to which business processes are outsourced. So if you're outsourcing payroll or service center to India, for instance, you're processing personal data in India, you can't rely on an adequacy finding as being the basis on which data can be transferred from the European Union to India, because India is simply not on the list that the European Commission has defined as being adequate. So that means that you have to, as an organization, if you wish to transfer data, and processing, just to be clear, includes allowing access to. So it's not simply shipping data digitally to another country, it's allowing people in another country to access data held on a server inside the European Union. So if you're processing data which is based, say, in the Amazon cloud in Ireland, but you allow operatives in India or Malaysia or the United States to access that data, technically that data is being processed outside the European Union, and you therefore need to identify the basis on which that processing is taking place, that transfer is taking place, in order to ensure that it's being done legitimately. You can't really do that entirely on the basis of your own assessment of the adequacy. You need to go a little bit further than that unless you can identify specific derogations that might apply. Yes, member states can make their own decisions. There are ways in which the supervisory authorities can agree that there are adequate safeguards in place, and where that's happened, those will remain in place until amended or repealed. But in principle, unless there is a basis of adequacy, you've got to look very hard at what the other options are. And the other options start with legally binding agreements between organizations, contracts between a country inside the European Union and one outside. You need to have what are called standard contract clauses, or standard data protection clauses, which allow data to be transferred from an organization in the European Union to an organization in outside the EU, or there is perhaps a code of conduct to which you can demonstrate that you're in compliance, or a certification mechanism. GDPR provides for both of those, although neither of those actually exists outside, to a limited extent, of the EU-US Privacy Shield, or what are called binding corporate rules. And I'll look in particular at the standard contract clauses, binding corporate rules, and the notion of a code of compliance, particularly in relation to the United States. Before we do that, there are some areas in which what are called derogations apply, and derogations are the areas in which organizations can decide to transfer data even though they don't meet one of the other requirements. Or another way, you can identify that it's legal for you not to comply with the clearly stated requirements. The first is where you have the individual's explicit and informed consent to transfer that data. And explicit and informed consent means the individual has to understand exactly what the risks are, know exactly how long the data is going to be processed, what's going to happen to it, and they have to have consented very clearly on the basis to exactly that. You can't bundle that type of consent with other consents. It has to be explicit and informed. It can be where it's necessary for the performance of a contract between the individual and the organization, or for pre-contractual steps. In other words, it's clear in the contract that that's what's going to happen to the data, and the contract in the data subject agreeing to the contract, they're agreeing to the specific processing of the data. It's necessary for performance of the contract. It's necessary for reasons of public interest, to defend legal claims, or to protect the vital interests of the data subject. So those are potential areas of derogation, just as is the circumstances which can apply to one-off transfers. And this is dealing, for instance, with a situation where somebody might book with a holiday firm in the United Kingdom, who's then going to make a booking for them in Panama, for instance. Panama, there is no adequacy finding, but the UK booking company might want to transfer the customer's data to the hotel in Panama. You can do that where, in spite of the fact there's no adequacy finding, no other existing rules, but where you can demonstrate that it's related to a very limited number of individuals. It's necessary for the compelling legitimate interests of the organization and of the individual, and you've put in place suitable safeguards to ensure that the data subjects' rights and freedoms are protected. And you have to be clear that the rights and freedoms of the data subject are protected. You can't transfer the data and then say, when there is a breach at the recipient, say that's too bad, I couldn't do anything about it, because as the data controller, you're responsible for determining whether the derogation applies or not. And the reality is that the vast majority of organizations are not going to seek to operate under the terms of the derogations. They're going to seek to operate under either an adequacy finding, a standard contract clause, or a binding corporate rule. And they're going to do that because it's a heck of a lot simpler. If every time you want to transfer data of one or two individual data subjects, you've got to go through a complex process, not only of ensuring that the data is secure, but demonstrating through risk assessment and audit trail that you've done what you needed to do. It gets to be a very expensive activity. So practically speaking, you want to deal with data transfers outside of the European Economic Area on the basis, first of all, of a set of standard contract clauses, and the European Commission has published a set of standard contract clauses. You can download them from the link which you see there. Just bearing in mind that at the moment these standard contract clauses are relevant for the Data Protection Directive. They haven't yet been updated for the General Data Protection Regulation. We'd expect to see those updates occur sometime in the course of the next 12 months. But of course you should currently be complying with the enacted version of the Data Protection Directive in the jurisdiction within which you're based. And so if you're currently transferring data outside the European Union, you should in any case be complying with either an adequacy finding or standard contract clauses or binding corporate rules. And standard corporate clauses or model contract clauses, said you can download them. The most recent set are largely thought to be the most useful. There is a set for controller to controller transfers and a set for controller to processor transfers. Those are different types of transfers, different types of exposures that each organization has, and there's a set of FAQs on the use of those model contract clauses. The key things to bear in mind about model contract clauses is that while you can incorporate them into existing agreements with suppliers or partners outside the European Union, and while you can also use them on a standalone basis to deal with data protection issues, you can't change or amend them. They're not templates which you can adjust and amend to suit yourself. They're clauses which have to be put in place and used exactly as created. You can add an additional party, such as an additional data importer, but you can't go and change the clauses, and you can't do anything outside of those clauses to change the effect of the clause. In other words, the clauses meet the European Union's requirements around legal protection for the rights and freedoms of data subjects. There are, if you're dealing internationally, if you have multiple, if you have hundreds perhaps of partners or suppliers outside the European Union, the challenge then is you have to have a set of contracts, a new contract with every single one of those partners or suppliers. You need to make sure that you're dealing with transfers between those entities on a consistent basis. You need to potentially be auditing all of those relationships. You need to be ensuring that contracts are kept up to date. You need to make sure that your partners, those who've agreed on the other side of the contract are in compliance with them, and the compliance obligations and the cost therefore of compliance are significant, and for organizations therefore a significant commercial burden. Inside a large international organization where you've got a single entity that controls how data is processed throughout all of the subsidiaries or member companies of that organization, then a different model is possible. It's what's called binding corporate rules. Binding corporate rules, there's not a standard set of documents that you can refer to. There is a set of guidance on how to create binding corporate rules, but essentially you'd go to your lawyers, you'd want legal advisors who are versed in dealing with binding corporate rules, and you'd have them put together you'd have them draft a set of BCRs that apply to your organization, which you're capable of enforcing across all of the member companies of the organization. Those BCRs then need to be cleared by a supervisory authority. You probably choose a lead supervisory authority, and you then start the complex process of applying to have your drafted BCRs approved. There's a standard application form, there's a BCR checklist. You can download the current set of checklist guidance from the ICO's website, again on the link which you see on this slide. Once you've got your lead supervisory authority happy that the basis on which you're transferring data is satisfactory, then you can export data from all across the European Union on the basis you've met the requirements of that lead supervisory authority. You have to bear in mind that binding corporate rules do not apply to transfers made outside of the group, nor do they work for a single international entity. They're designed for transfers within an international entity or international group of companies. So the benefits are that they provide an effective framework. They do bring with them an ongoing obligation to monitor compliance, so regular audits, regular internal training for staff who are handling personal data, regular compliance monitoring. You need to be able to demonstrate if there is a breach that it's in spite of the fact that your binding corporate rules are in effect, not because your binding corporate rules were weak and ineffective. So benefits are clarity, internal framework. You don't need multiple contracts to cover multiple transfers of data. You simply have a standard set of rules in place across the whole of your organization. And organizations can and do this in order to transfer data to parent companies, to partner companies, and to suppliers in the United States. But the transatlantic data flow is a very substantial one, and for quite a long period of time under the Data Protection Directive, arrangements were in place to enable US organizations to find a safe harbor from prosecution for processing the data of from EU organizations under what was called the Safe Harbor framework. And the reason why there needs to be a Safe Harbor framework is the United States, first of all, does not have a nationwide, a federal level data protection law. It has a range of different state level laws. There are some 47 different data breach laws in different member states. They all have different requirements. So there's no consistent basis on which European Union citizens can know that their rights will be protected across the whole of the European Union, which is why, as things stand, it's highly unlikely that there will be an adequacy finding for data protection in favor of GDPR. The Safe Harbor framework was declared invalid. A EU data subject came to the view that the Safe Harbor framework didn't actually provide genuine protection for his data, brought a case which in the end the European Court of Justice upheld, and so the Safe Harbor framework was declared invalid in 2015, and that meant that most organizations processing data from the US in the US had to move very quickly to put in place either binding corporate rules or standard stroke model contract clauses, or to stop processing. By July of last year, the European Union and the US, through the Department of Commerce, had stitched together what's called the EU-US Privacy Shield. It was adopted by the European Commission in July last year, and what it in effect does is confer a finding of adequacy on any organization which registers under the EU-US Privacy Shield and makes a statement of compliance to the requirements of the Privacy Shield. The Privacy Shield really has four key components to it. The first is a recognition that across the commercial sector, organizations have to comply with, and at the moment, the EU-US Privacy Shield is Data Protection Directive focused, not GDPR, so it focuses on demonstration that organizations are compliant with the Data Protection Directive, and that there's a robust enforcement mechanism that enables supervisory authorities in the European Union to ensure that controllers and processors in the US do comply with their obligations. There are clear safeguards and transparency obligations put in place as part of the Privacy Shield to restrict the access of the US government to the data of citizens, of EU data subjects. EU data subjects get rights of redress, which are set out very clearly, so they have a right of redress directly with the company it's concerned, as well as with the Data Protection Authority, as well as with the Privacy Shield panel. So the rights of data subjects, which was where we started this webinar, are seen as being protected very strongly through the EU-US Privacy Shield. And both the Department of Trade and Commerce and the Department of Commerce in the US and the European Union are committed to monitoring the effectiveness of the EU-US Privacy Shield to ensure that it continues to meet the requirements, and if it does, for it to be renewed on an annual basis. It's worth noting that there are some members, some entities within the United States whose concern about the executive branch's interference in data processing has led them to suggest to the European Commission that the Privacy Shield be revoked, and while those suggestions have been apparently investigated, there's been no decision as at date to revoke the Privacy Shield, and there may not be, but it's important to be aware that this is a two-way set of concerns. Any organization that is processing the data of EU data subjects ought right now to be registered under the EU-US Privacy Shield. It is a more onerous process than under the Safe Harbor framework. Organizations effectively have to self-certify that they're in compliance. They have to make a statement that they're in compliance, an officer of the company, which means that if you're not, then there is the potential, if there is a breach, of significant actions being taken against the company and against anybody who falsely certified. They're designed, though, the requirements of the Privacy Shield are designed so that organizations of any size can meet the obligations. During the self-certification process, organizations have to describe who they are. That's the obvious right of data subjects to know who's processing their data, and that means if you're in the European Union, data subjects have got the rights to know who you are and how to contact you. They've got the right to know how their complaints will be investigated, as well as obviously a mechanism for bringing complaints, and they have a right to know what your privacy policy is, how you're going to protect data, how long you're going to hold it for, who's going to have access to it, all of the things which should be part of a standard privacy policy notice to data subjects. The organization's privacy policy, if you're going to meet the framework requirements, has to include a very obvious reference to the Privacy Shield and provide a link for data subjects to the Privacy Shield so that data subjects can get clear about how to exercise their rights as data subjects. There are 7 principles to the Privacy Shield that organizations seeking to demonstrate compliance with have to follow. The first is that they'll give proper notice to data subjects of how data is being processed. They will allow data subjects to exercise choice properly in relation to data processing. They won't enforce consent. They won't bundle consent. It'll be a proper, properly fragmented or disaggregated set of consent options. They will, where they are contracting with a further processor, recognize their accountability for onward transfer of data. They will ensure that appropriate levels of security for confidentiality, integrity, and availability are in place, that the processing of the data will be limited only to the purposes for which it was lawfully collected, what we call purpose limitation in data integrity. Access to data will be again limited to the purposes for which it was collected, and data subjects will have all of their rights of recourse, enforcement and liability all protected. And those are the principles which are built into the Privacy Shield. And of course, for all organizations and for all data subjects operating in today's environment, the extent to which businesses migrated to the web to the cloud means that clarity about where data is being processed is a significant challenge. You can look around you can look on Google or Yahoo or Bing You can look for any organization, you'll find a multiplicity of different cloud-based organizations, all of whom are processing data. And processing data, remember, includes just the names and contact details of data subjects, and data subjects details include their business email address. The business email address is just as much personal data as is home contact information. So a very wide range of organizations processing data. Controllers may, through their marketing activity, procurement activity, business partnership, all of those kind of areas, be partnered with any one of these organizations. Many organizations will recruit, for instance, through LinkedIn, will share data through Dropbox, will use Hootsuite or LogMeIn or GoToMeeting as part of their marketing activity, and therefore being really clear about where data is being handled is important. You might, for instance, deploy one login as the method for ensuring that your staff can log into data wherever they might be operating from, and you need to be sure that if you're using one login, very straightforward, that if you're based in the European Union, the data is being processed where you know it's being processed, so that when you get an email from one login today saying they've been breached in the US, you know whether or not that includes your data. Cloud services, apps, a significant challenge for all organizations because of the issues about where data is being transferred. And this is an issue because Article 27 says very clearly that representatives, that controllers or processors not based in the European Union but who are providing services into the European Union need to comply with the regulation, and they need to appoint a representative inside the EU. Has to be appointed in writing, has to be capable of being approached by data subjects or by the supervisory authorities where there are breaches or other exploratory or enforcement action to be taken. But the appointment of the representative doesn't absolve the controller or processor from their own legal liabilities. And bear in mind that the definition of providing services includes if your website has a delivery address inside the European Union, by definition you're providing services into the European Union. If you process payments in euros, you're by definition providing services into the European Union. So it's only organizations outside the EU but who are not providing services into, who are not caught by the global scope of GDPR. And just to be clear, if you're an organization operating in Oregon, you're not providing services into the European Union, but an EU data subject comes and books into the hotel for a couple of weeks. The fact that they happen to live in the European Union doesn't suddenly oblige you in Oregon to comply with GDPR. You're not providing services into the European Union. The fact that someone from the EU has come to do business with you is their lookout. You're not obliged to comply with GDPR. But otherwise, if you're providing services into, yes, you have to comply. Not complying, as we've seen, carries potentially significant fines. If you're a processor, and quite often cloud-based organizations will be processing data on behalf of controllers in the European Union. Sometimes the controller will be in the United States collecting data on behalf of the of an EU processor. It could be either way around. Any organization that is not a controller but is processing data must by law be a processor. You can either be a controller or a processor, but you can't be nothing. Controllers obviously can process information themselves. A processor is defined as the organization to whom processing has been outsourced or who's processing on behalf of a controller. A processor has to have a contract with a controller. You can only process data on documented instructions from the controller, and that means that a cloud-based organization providing hosting services needs to have a contract with a controller that enables it to do so in line with that obligation. If you're breached wherever you are, you've got to help the controller comply with their reporting obligation. So the onus is quite significant, and the challenge in particular for organizations based inside the European Union is to be really clear where any of their cloud-based partners or suppliers are based, because they need to make sure that where the data is going to enable them to meet their obligations to comply with the transborder data processing requirements of GDPR. Cloud is not automatically territorially limited. Part of the financial benefits of using a cloud-based provider is that you can move data around within the European Union, within the cloud-based infrastructure. It's available on a 24/7, 365 basis. You don't need to know where it's stored. All of those are amongst the financial and business benefits of cloud-based storage. However, the compliance benefits say no, not unless the data subject knows and you've got a legitimate reason for transferring data outside the European Union, or alternatively that the data subject has consented to it. So that means that you need to be very clear that there is a legitimate reason for transferring data outside the EU if that's what you're going to do. You need to remember that the data protection principles will still apply. As the controller, you're responsible for doing that. You are not in a position to say, gosh, our data processor turns out to be useless. As a result of that, we've got a whole bunch of problems and issues. You're the controller, you chose the processor, you're on the hook, you'll be fined. And so compliance with the law, you the controller have to ensure compliance with the law, either on the basis of an adequacy finding, if you can demonstrate clearly that there's a derogation that applies, but more likely if you can't identify an adequacy finding through standard contract clauses or binding corporate rules if you're an international organization. Certainly if you're an EU controller or processor and you're using a cloud-based supplier, one of the key things you'll want to do is make sure that their data is hosted, their business is hosted in the European Union, so AWS in Ireland, for instance, and that you're able to choose that option in setting up your hosting account. Where you're unable to choose that option, where data is going to be hosted internationally, not at your discretion, you need to be absolutely sure that you've got in place a mechanism that enables you to demonstrate compliance in relation to GDPR, and that includes informing data subjects that the data is being processed outside the European Union, and either adequacy finding or standard contract clauses or binding corporate rules in place to protect the data subject's rights. Remember that data subjects' rights, like the data protection principles, are at the heart of GDPR. Of course, as an organization, IT governance can help substantially with organizations in the UK, the European Union, and with the US in terms not just of GDPR compliance, and there's a significant amount of work to do around that, but also in ensuring that you're in a position to handle transported data flows in a way that will be legal. Data practitioners are very substantially legally backgrounded folk who can combine the understanding of what the law says with what practical requirements are and help organizations find practical solutions to how you address the very specific requirements that you have around moving data outside the European Union. There's quite a lot of self-help materials available, our best-selling pocket guide, our documentation toolkit, gap assessment tool, implementation manual, all of them available on all of our websites in local currencies. And you can access those now. As I said, the slides will be going out to everybody on the webinar. You'll be able to click through on those links when you get the slides, but you don't need to wait. You can go onto our websites and look under Data Protection Act / GDPR and find your way to any of the products and services today to help you address your GDPR requirements, which, folks, brings me, apart from a brief mention of our very best-selling training courses, foundation and practitioner internationally certified training courses which enable you to acquire the skills and knowledge you need to help your organizations meet your compliance requirements, appropriate training courses for data protection officers and so on. Apart from those, brings me to the end of what I was preparing to say, and so that brings me into the Q&A part of the webinar. So just give me a moment while I turn to whatever we've got in the way of questions, and I'm going to work through the questions we've got, and what I'm going to do is I'm going to read them out. So if any of you still have questions, please do put them into the question function, type them in. I'll pick them up as fast as I can get to them. So will there be any standard for GDPR, i.e. similar to ISO 27001:2013? The answer is that GDPR makes provision for standards to be a method of demonstrating compliance. ISO 27001 already meets the requirements in terms of information security, but not necessarily in terms of personal information management. We expect that additional standards will emerge. BS 10012, the British standard, may become one such. It was written with GDPR in mind, but while the regulation provides for standards that will enable you to demonstrate compliance without actually proving compliance, and there's an important difference because compliance in the end will be decided by law courts, standards either exist or are emerging. If an IT processor provides IT infrastructure services to a company but has no access to that data, what would be the expectation from the regulator? Well, if you're providing infrastructure services, including backup, you're processing the data. So archiving is defined as processing, and therefore archiving or backup is a processing activity, and the controller, the organization that's collected that data, needs to make sure that you, the organization that's providing archiving and backup services, has a contract that sets out clearly your obligations to protect the data, which ensures the data is available if the data subject wishes to exercise their right of access, and the data subject is aware of the data if the data subject wishes to exercise their right to be forgotten, then it has to be forgotten wherever it's being held. So even though you can't see the data, the fact that you're providing backup services means that you're caught by GDPR in that specific way. Does viewing a CRM record of personal data on your laptop in a hotel room in South America count as taking the data outside the EU? Yes, is the simple answer. Ridiculous as it may sound, the definition of processing says very clearly accessing, viewing, structuring, sharing data is defined as processing, and if you think about it, the fact that you can look at a piece of data could mean that someone can take a photograph of it, could mean that it could be written down. All of those kind of things mean that it's available, accessible, it's being processed. So while we might expect to see legal decisions in case law over the next few years eliminate some of the more simplistic descriptions of processing, at the moment the safe route is to assume that the definition of processing applies exactly as defined. If an internal employee within a control or processor gains accidental access to a file containing information with EU personal data, and the internal employee immediately closes the file and does not misuse or leak this information, is this considered a data breach? Data breach includes accidental breach. It very specifically says, if you remember, the personal data breach is both accidental and deliberate. So yes, it constitutes a breach. The issue is whether or not you need to report it to the Information Commissioner, and I would say that you probably don't. You don't need to report data breaches where there is no risk to the rights and freedoms of data subjects, and I would say in this instance there was no risk. So as long as you can, through your internal processes, demonstrate that those decisions are being made properly, centrally, so you've got an internal breach reporting process which collects and defines incidents and decides on them, I would say that deciding not to report that was a perfectly legitimate thing to do. In relation to the right to be deleted, what kind of a proof companies have to provide to the person that requested it? Well, you have to be able to demonstrate that it's been deleted, and that can be very difficult where data is I mean, ultimately somebody would be entitled to have a court order to find evidence to prove that it's been deleted. It can be difficult at this current technology to genuinely delete information from backups or from hard drives, and so various codes of practice from information commissioners provide for mechanisms that you can put in place to demonstrate the data is beyond practical use, and you could rely on one of those if you're doing that to demonstrate that you've met the requirement to delete the data until such time as technologies make it possible. There's a phrase in GDPR which talks about state of the art. Is caching data purely for performance reasons considered data transfer? Yes, I would say it is. The fact that you're caching it means if you're caching it outside the European Union, it's being transferred. It can be accessed. So yes, I think it's a yes, I agree, individuals' consent has to be explicit and conformed. What is the practical difference between the approved code of conduct and the binding corporate rules? Approved code of conduct is an approved code of conduct which is approved by an information commission or supervisory authority. In terms of GDPR, none of those currently exist. Binding corporate rules are contractual and contractually enforceable clauses which you create and put in place between the member companies of an international organization. So as approved codes of conduct emerge, you'll be able to turn to those to find a simpler route potentially than binding corporate rules, but not yet. Is pseudonymization being used when sending information to third parties in countries outside approved countries? Pseudonymization is simply a method of applying security. It's not a method of removing data from the scope of GDPR. So if data is anonymous, which means you can't identify a data subject from the data, then it's outside scope. But if you can still, by reconstructing the data, identify a data subject, it's still subject to the data transfer requirements. Pseudonymization is a good security control to put in place, but it's not adequate to enable you to meet, to avoid the requirements to meet the data transfer obligations. Our small organization uses Xero for accounting purposes. Xero state their data centers are based in the USA. What information, if any, about this do we need to inform our clients about? From a GDPR point of view, B2B clients, their personal data is personal data. GDPR makes no differentiation between personal and private data because it's all information that can identify data subjects. GDPR says that even an IP address is personal data, and therefore using an organization that is based in the United States, where at the very least it's going to be collecting the information of you, its customer, all of your staff using it. That customer information is processing your personal data outside the European Union. It needs to, in order to do that, it's clearly providing service into the European Union. It needs to meet, and you need to find evidence that it meets one of the bases on which it can transfer data outside the European Union. If you also use Xero for payroll transfer, then staff need to be aware of the fact that data is being transferred out. All of the requirements that apply to processing outside the European Union will apply. If you utilize standard contract clauses, do you still need to comply with the Privacy Shield? No, it's an either or. Privacy Shield in effect gives you an adequacy finding in respect of companies that are registered under it. Many organizations we know have stuck with standard contract clauses and Privacy Shield because it's belt and braces. If the Privacy Shield gets withdrawn, then at least they know their processing can continue. But no, it's an either or. You don't have to have both. GDPR will replace the current Data Protection Act. The Data Protection Act in effect is withdrawn on the day that the Data Protection Directive comes into force, so that you will need to be in compliance on the 25th of May next year with all of the requirements of GDPR. You won't be able to say, can I have a transition period from now on, please, because you are meant to have met that compliance requirement. And I'm just going to pick out a few more. We'll try and answer all of them. There are very many more questions than we've got time for. Is it possible to ask a more general question on GDPR? Yes. Is it correct to assume that CCTV footage is governed by the regulation only when the natural person can be identified by data attached to the footage? I'm thinking in particular about retail systems which may capture a customer number and transaction detail alongside the footage. So the simple answer is that CCTV is almost certainly capturing personal information. Biometric data, which includes the ability to identify somebody by face, any related transactional information, all of that counts as personal information. You're collecting the data, the personal data, in order to identify data subjects. So yes, unquestionably, even under the Data Protection Act, the regulation applies. The requirement becomes more extreme under GDPR. Yes, you should in any case right now be telling data subjects what you're doing. They should get a fair processing notice, and those obligations get more substantial under GDPR. In the UK, you can currently download a code of practice, a guidance document from the Information Commissioner about processing data and using CCTV. It will apply to whether that data is held inside the European Union or outside of it. Very good current question: what if encryption backdoors are introduced by government legislation? How would this affect your ability to use encryption to protect data? And I'm afraid that's in the long run going to be decided by Supreme Courts. The short answer is that if data is encrypted, you almost certainly can use that as a basis for determining that there is no risk if there is a breach to the rights and freedoms of data subjects, and therefore you don't need to report the breach. If there is a government mandated backdoor which is put in, then I think we're going to have to leave that to the European Commission and the law courts to determine whether or not that invalidates the general guidance that encryption is a way of making data safe. And so the last question I'm going to pick up is, as a business handling B2B data, do the same rules apply? Yes. GDPR makes absolutely no differentiation between B2B and B2C. It's all personal information. Alan Calder at IT Governance is an email address that identifies me just as much as Alan Calder at gmail.com might. As a data subject, I'm entitled to have my business email address as much as my personal email address, and all of the associated data protected. So there are no simple opt-outs under GDPR. Arguably, they don't exist under the Data Protection Directive, but that's a separate subject. They certainly don't under GDPR. And ladies and gentlemen, that brings us to the end of the hour which is allocated to this webinar. I'd like to thank you all for being there. There's a substantial number of other questions which we've not had time to answer. I'll try and get my existing answers to these questions plus answers to all of the rest updated. We've already got a series of FAQs which we publish. I'll get these questions and answers and the additional answers to the additional questions tried to update it through our GDPR consultancy and international data transfer advisory team over the course of the next few days, and we'll publish all of that information. And that then just leads me to say thank you all for being here. I know there is an ongoing series of webinars both on specific subjects inside GDPR, but also for organizations who are new to the subject, introductory webinars. If those can be useful, please do. You can sign up to them on our website. Please do feel free to do so. Thank you for being with us today, and good luck on your GDPR journey. Good day.